Hello, Stephanie Joy with All Things Social Security. We had a Q&A with a short little clip discussion on a particular topic. So I'm going to attach it for you here. It might be something that you're interested in if you clicked on this header. And following that, we're going to go through it a little bit more. So just wanted to give you the heads up. This is where it started from, and then we'll have the bigger discussion right after. All right, chat with you later. Bye-bye. S. Lewis says, you mentioned problems with or reasons people don't take meds. What if meds make the stomach hurt and cause vomiting? Exactly. To me, that's a great reason not to take the med, but it's no good if you don't tell your doctor and it's not in your medical records, right? Makes sense? So I would be getting that in that medical record one way or the other. I would be calling and leaving a message to say, I got to talk to Dr. So-and-so. This medicine is causing me so much stomach pain and it makes me vomit. I need to stop taking this. Please tell them to call me so we can figure out safest way and what I should switch to. You can call, you can message in the portal. If there's a portal, you can fax a letter. I know sometimes it's hard to get medical providers to properly put communications in the file. I think that's malpractice, but I bitch about that all the time. It's probably one of the number one reasons, unless it's painkillers. And then we also have the fear of addiction. Both are fabulous reasons, I think. Good afternoon. Okay, there has been it seems like a panic out there this last week or so over a 10th Circuit federal decision regarding to what extent an ALJ or the SSA in general has to consider someone's allegations of side effects of medications when the medical evidence in their treatment records, which is the medical evidence of record, it's the stuff that relates to them, not what's out there, fails to know any significant side effects. So there is no new rule, guys. There just isn't. This particular circuit case is just explaining that the rule remains the same when I think a particular claimant was seeking to maybe stretch the rule, understandably so, if you have a claim, but that wasn't going to fly. So I believe the case we're talking about is James versus Commissioner. It was published on March 15th, 2024. And I just wanted to point out a couple, the denial. And there was a couple interest, and I will post I will put a button with this case and also with the fact that this isn't a new rule, guys. It's not a new rule and there's nothing to be afraid of. If you have proper representation, your representative would be telling you that when you have side effects that affect you in any way more than, minutia, you should be reporting it to your doctor or doctors, all of them or any of them, because that's how it gets up in the medical record versus not mentioning it. And then at hearing suddenly saying that you're debilitated by side effects and have to sleep half the day away. Not going to work. And I think we could all maybe agree that that shouldn't work. Now that's a whole other issue from if you have issues getting your complaints put into your medical record by your doctors, if they are falling down the job, which is very sadly not uncommon. But there are potential ways to get those things in there. And that's, a story for a different day. But in the end, you need to get your complaints of your medical problems, which includes side effects from medications, just as it would include side effects from surgeries and side effects of anything. It's all medical. You want to have those noted that you've been complaining about them all along, not a one-hit wonder either. So the thing I wanted to just quote from the case, so here's one paragraph when they were analyzing it. The commissioner, that means the SSA, has a two-step process for evaluating a claimant's symptoms, that is, his or her subjective statements about his or her impairments or limitations. At the first step, the ALJ determines whether the claimant has a medically determinable impairment that could reasonably be expected to produce the pain or other symptoms alleged. So first you're deciding if the impairment, which could include those medications, could reasonably be expected to produce those. Doesn't mean they have to, but it could be reasonable. At the second step, the ALJs, they will evaluate the intensity and persistence of the claimant's symptoms and determine the extent to which a claimant's symptoms limit his or her ability to perform work-related activities. Okay, that's obvious. In making this evaluation, the ALJ considers the medical evidence of record, along with several other factors, including the claimant's activities of daily living. By the way, activities of daily living would generally be, although not necessarily limited only to this, your function report. The function report that we drive home again and again and again, how important it is to not leave important things out and not add things that feel good to add that have no bearing on the legal questions that are actually going to come out of those answers. In this particular case, apparently the medical evidence of record, that's the objective evidence, did not in any way suggest significant side effects. So there weren't complaints from the claimant about significant side effects, certainly not in recent years. And her status exams, like mental status exams, seem to all, the examiner would state, or the treating provider, that she looks good today, she's articulate, she's on the ball, So those things are going to kind of fly in the face of a sudden assertion that my medications themselves wipe me out and keep me in bed half the day. So, and this part I thought was telling. James, that was the claimant, right? Points to warning labels that accompany opioid medications and a physician's reference book as evidence that she suffered debilitating side effects. So she's relying on literature about potential side effects as proof that she suffers them, even though for years her medical records apparently did not evidence significant side effects. The court goes on to say that this evidence is unpersuasive because the ALJ was required to determine the claimant's residual functional capacity based on the record, not warnings about potential side effects. That makes sense, right? That you either have them or you don't. The fact that you could have them doesn't mean you do. I mean, that's why many people that are on opioid medications are able to work in some shape or form. The court goes on to note that the claimant relies primarily on her doctor's warning against working, driving, and operating heavy machinery while medicated. Well, that could be true. And I have a feeling that the jobs they picked out for her didn't even include working or driving or operating heavy machinery as part of her job. So it really wouldn't have eliminated all jobs anyway. But the court goes on to say that this warning is not evidence that she experienced these potential side effects. At most, it is evidence that her medications could cause side effects, not that they did. And guys, that is nothing new whatsoever. Now, I have had arguments where I too will point out what the literature says common side effects are. However, my client has already been complaining about side effects in her function report, in her visits with her doctors. So it's not like it's pulled out of the rear at the time of a hearing. So in this case, it looks like there was no such. I mean, they go into a little bit about what she said in her function report about her ADLs, and they're pretty innocuous. I mean, there was no mention of, having to sleep half the day away. So while I think side effects are hugely important, and I emphasize them all the time, don't think you're going to be able to mention them at a hearing and then flip the script. It's all about the objective medical evidence. And when subjective complaints of pain or side effects from medications, aka symptoms, are noted, you really do need to make sure they get in the medical record, because at least they have to be shown that you've been complaining about them all along. Because symptoms, again, are not considered the same as signs or diagnostic proof. Okay, so that brings me to, further along, how this is not a new rule. So don't let anybody convince you that, suddenly, your side effects don't count. That is so not true. And that would be going to Social Security ruling 16-3P. It's for Social Security Disability and SSI, Titles 2 and Title 16, evaluation of symptoms and disability claims. And this ruling, they tell us, clarifies how the SSA considers 1, the intensity, persistence, functionally limiting effects of symptoms. Throw the side effects in with symptoms, because that's part of it. That is a symptom. Objective medical evidence when evaluating symptoms, other evidence when evaluating symptoms, and then also the factors set forth in 20 CFR 404 C3 and 416. This is the counterpart on the SSI side, 416.929 C3. The extent to which an individual's symptoms affect his or her ability to perform work-related activities or function independently, appropriately, and effectively in an age-appropriate manner for a child with a Title 16 disability claim. That last one is about the child if they have the side effects. Adjudication standards for evaluating symptoms in the sequential evaluation process. So, and hold on one second. I believe I have a dog barking. Hold on. I'm back. Okay, there is a paragraph in here that might be helpful. And again, this is from 2016. This is actually the SSR that replaced a previous SSR it used to be that they would talk about a claimant's credibility. And I think it was offensive to people. And understandably so. If someone says, we don't find you credible about your complaints of pain when you're in pain, that's going to be unfortunate. So they change it to something more about, is the statements about pain, instead of being not credible, are they consistent with the objective medical evidence of record, or are they not? So that's how they got around that little credibility thing. The end result is pretty much the same. But anyway, so this is from 2016, guys. This is not new with this 10th Circuit decision. So that is just a clarification to get it out there so people don't forget. They say here, and this is back from 2016, symptoms cannot always be measured objectively through clinical or laboratory diagnostic techniques. That is so true. We all know that, right? However, objective medical evidence is a useful indicator to help make reasonable conclusions about the intensity and persistence of symptoms, including the effects those symptoms may have on the ability to perform work-related activities, blah, blah, blah. We must consider whether an individual's statement about the intensity, persistence, and limiting effects of his or her symptoms are consistent with the medical signs, not medical symptoms, medical signs and laboratory findings of record. And there you have it. They have to find out, after they determine that it would be reasonable, that could be happening, to find out if they can find that it is happening. The individual statements about the intensity, persistence, and limiting effects of those symptoms, say the side effects, are they consistent with the medical signs and laboratory findings of record? And that's where you have it, guys. You have got to get this in your medical record. When you go to the doctor's office and they're filling out, sometimes you have to fill out like experiences of, your symptoms or whatever, make sure to put on there. Now, I was wondering when I was reading this case, some people who are very in favor of continuing their opioid or narcotic medications for pain, which is completely understandable, they might be playing down any side effects because they don't want their pain medication yanked from them. I totally get it. Pain, chronic pain, it's got to be the worst thing to go through life with, or one of them. But that playing down of the side effects and maybe just only saying they're mild or don't exist, or that can come and bite you in the butt. So if you have an SSD claim, so it's something you have to weigh, whether to be, how honest you choose to be with your providers could have a big effect on your case. Because if you're saying one thing to get something you want, and then you're saying another thing to get something else you want, and those two things don't jive, something's going to give. And probably generally it's going to be your case, because it's not like the SSA is going back to your doctor and saying, in his hearing, he said he has severe side effects from that medication. Doctor, there's privacy. Don't worry about that. There's no interference by the SSA in your treatment whatsoever, but you probably will lose your case, or potentially, if it's hinging on that. By and large, most people with serious disabilities have the objective evidence of severe limitations due to the medical impairment itself. The side effects is important when the limitations from your impairment don't knock you out of all jobs, but those side effects could. So you just got to be really diligent in communicating. If I were you and you're pro se and you're moving along and you don't know what your doctor's records say, I would be ordering my records. I would be making sure to have a copy, because you don't know if they're properly recording what you say. And if they're not, you got to do something about it. Maybe you're going to report it in a different way. It is a bit of a problem. So now with portals and stuff, I think you have a lot more opportunity to, get the facts in there when we have maybe less than competent or somewhat lazy people on the, in the doctor's office, not putting everything down that you say. Those computerized intakes, they all default to no problem. And there's a lot of cut and pasting too, as we are seeing and has been complained about in other venues a lot. So anywho, I'm going to link both of these. I'm going to try to put a button up for both of them. So you can just, somewhere up here, you'll find it. And you can read these yourself. The case is really short. So if you want to hear what we're talking about, just go read the case. It is not long. It is pretty short. And it's well taken because everyone needs to be reminded of this. I nag my clients religiously about communicating their side effects to their doctors. I think it's in some of my facts that they get that they have to read and presumably comply with, that you got to make those complaints known. And if there's a problem getting them in the record, if you're my client, let me know and we will brainstorm about how to improve that. But super important. Anyway, thanks guys. Talk to you later.